Mr. Chairman.
It's not I'll call the honourable member Dennis O'Rourke.
Thank you, Mr. Chairman. I did want to make some brief comments about Part 2, in particular Clause 21. But before doing so, would also like to say this, that there was, I think quite recently really, a television advertisement for mainland cheese. And of course, the best cheese does come from the mainland, and this company produced it. And their theme in their advertisement was good things take time. And indeed, their product was a superb product, and still is, and did take time. And they were very memorable advertisements, and what they said most people believe to be true. And in the case of this particular piece of legislation, it has taken time, it has matured properly, it has been considered properly, and we've got a good product. So good things take time. This took time. We get a good piece of legislation out of it, especially with regard to the input of the Law Society and the other submitters indeed. And I would like to reiterate also what many others have said, that it is a shame that with the previous legislation, the GCSB one, that we're not seeing that. We're not seeing the government take time. We're not seeing the electorate having the time to make a good and considered submission on that legislation as it has on this. So that is a matter for considerable regret. We can easily agree to legislation of this kind, which has been well considered, and of course it cannot be expected that any of the opposition parties would be prepared to support the sort of process we saw yesterday with the GCSB legislation. However, I did particularly want to mention one clause in Part 2. And the reason I do so is because in the first reading I questioned the Clause 21, which amends Section 8, and that concerns jurisdiction in respect of crimes on ships or aircraft beyond New Zealand. And this provision would replace Section 8.2 with two new provisions. The first providing that if a person does or omits to do any act to which Section 8 applies, and that act or omission would, if it occurred in New Zealand, be an offence punishable by imprisonment for life or by 2 or more years imprisonment, then the person is liable on conviction as if the act or omission had occurred in New Zealand, and that's fine. The second, however, provides that if any proceedings are taken by virtue of the jurisdiction conferred by Section 8, it is a defence to prove that the act or omission would not have been an offence under the law of the country of which the person charged was a national or citizen at the time of the act or omission, if it had occurred in that country. So that means that a New Zealand citizen would potentially be treated quite differently from the national or citizen of another country for the same offence in the same circumstances. So I questioned whether that was appropriate at the Select Committee stage, and it did receive proper consideration. The officials were able to satisfy me that this wasn't really a change at all, that it has been for some time a provision in New Zealand law and would be consistent with the legal systems of other countries, and that it would be unwise not to have such a provision in our own statute. So I just wanted to mention that, as I said at the beginning, these sorts of provisions need to be scrutinised. We need to get it right. We need to understand indeed what we're doing and to make sure that they are correct and proper provisions. So, as I said, Mr. Chairman, good things do take time. We have scrutinised that provision along with the others. We have satisfied ourselves that it is the right law and therefore it deserves support. So I just thought I'd place on record, having raised my concern at the first reading, that concern has now been allayed, and I'm satisfied that this provision is good and proper and should be passed.
Thank you. I call the honourable member Andrew Little.